Number 29, the people of the state of New York versus Rafael Perez. Counsel?
Good afternoon, and it may please the court. I'm Steve Moralia for appellant Rafael Perez. I would like to reserve 2 minutes for rebuttal, please.
You may, sir.
Thank you, Your Honor. This case presents two separate questions. One is a de Boer issue involving a search, and the other is a Miranda issue. And I'll start with the de Boer issue first. In this case, the appellate division erred by essentially conflating the levels under the de Boer analysis.
And counsel, which level are you challenging here? Is it the initial approach? Is it level 3? What are your specific challenges under the de Boer framework?
Your Honor, there's a couple of them, two of them actually. First, the first challenge is to the initial approach and questioning.
That being, I'm sorry, on the 9th floor?
On the 7th floor.
On the 7th floor.
The elevator's doors open and my client walks out with some others, and then according to the testimony, the police officer sees him and he retreats back into the elevator, and then the police ask him to hold the door and he keeps pushing the door close button.
So that contact right there, you're saying violated level 1?
I'm saying that contact could not provide an additional degree of suspicion when they once again,
it doesn't really need an
floor.
additional degree. What they need is an objectively reasonable degree for the initial inquiry, right?
Yes.
So is the question then for us the not holding the elevator, but when you ask somebody to hold the elevator for you and they're trying to close the door on you, which is the way I think the people are arguing it, is that an objectively reasonable basis for the approach?
Your Honor,
Agree that's the initial question for us.
yes, I would probably have to agree that could provide the additional circumstance, in addition to, the Barksdale kind of situation where you had the presence in the secure building in the TAP program. Here, there was the initial
I don't know
request.
if the TAP program is relevant because he lived there. So, I don't know if the TAP program is particularly relevant.
Yes, well, you're right. But when the encounter again commences on the 9th floor, the police at that time, at the very most, had an objective, credible reason to approach. And my client had the right
So you're saying on the 9th floor, it's a level 1?
Yes. By the time that they get there, at the most, it's a level 1 right to ask a, informational question.
So at what point does it escalate? Does it go to level 2, or is it your position it goes to level 3?
The police act in their level of intrusion. They escalate the intrusion without a corresponding increase in the level of suspicion. And my contention is that the conduct and the remaining silent on the part of my client is not a circumstance which can elevate the level of suspicion.
Why doesn't observation of the bulge do it?
Your Honor, the observation of the bulge here, it was a nondescript bulge in the sleeve, and it wasn't the kind of classic outline of a weapon or a waistband bulge.
Well, how about together with the fact that he had his arm stiff and straight down?
Yeah,
Does that add anything to it?
It doesn't really add anything to whether it was the classic example of a concealed weapon like a gun or something.
What if there had been testimony, which I don't think there was here, what if there had been testimony that in this officer's experience, based on other arrests or other inquiries or whatever, that bulge in that particular area with the arm straight down was indicative of a machete?
Right. Well, we don't in this record have that. I suppose
But would that be enough?
I suppose in a case where the officer testifies that, based upon the particular outline in his experience, he was drawing the objectively reasonable conclusion
But
that a
in
weapon
this
was
case,
concealed.
the officer did not know about robberies with a machete, correct?
No. In fact, when the elevator doors open on the 7th floor and my client walks out and walks back in, that's the first time they've ever seen him. They have no
Does he say
idea.
what hand?
The right arm.
Is there a stiff arm? Does he say what hand is
The
being
right-
used to keep the door closed? Doesn't he say he's pressing the button to keep it closed?
Yes, I'm not sure that that's in the record. Repeatedly pressing the door button.
So clarify for me then, what's the record? The police just assume that he stepped back and didn't do anything, as opposed to he affirmatively tried to immediately have the door closed by pressing the button?
Yes, well, the appellate division below characterized it as the apparent panicked attempt to leave the presence of the police. And I would suggest that there's no support in the record for concluding that it was a panicked attempt other than, the evident desire to be on his way. I mean, there's nothing from which you can conclude that it was a panicked attempt to leave. It could be rudeness, for example. So that's why, it's consistent with his right to not interact with the police, to decline to have that interaction altogether. And of course, that's consistent with both levels 1 and 2.
So what would have been necessary, other than what Judge Stein has already mentioned regarding the bulge? What would have been necessary to allow this to escalate to the appropriate level to support the actual touching of the defendant, eventually arresting him?
Right. There would have to be testimony that the officer saw an object or an item that he concluded was a weapon. Here, he just says he felt for his safety, and he, at that point, immediately reached in and grabbed the arm without articulating why it was that he reached that conclusion. There's nothing descriptive about it other than it was one arm larger than the other being held at his sides. And as the court noted, at that point, they had no idea that those police officers doing
Hadn't he asked him if he lived in the building a number of times and not gotten a response?
Yes, he asked a number of times. And again, that will be consistent with his right to decline interaction with the police at that point.
That may be true, but the bulge in the sleeve, combined with not answering, combined with trying to avoid the police in the elevator, doesn't that get us to level 2?
No, I would suggest, Your Honor, that it doesn't, because the conduct of declining interaction remains consistent with the right to be let
What
alone.
about
So,
the
counsel,
fact
your
that he's not-
position is that the police officer's belief that there was a weapon under the sleeve was unreasonable under the circumstances presented on this record? Is that
Yes, that it's objectively, that the record doesn't support that it was not objectively not reasonable to conclude that he was in possession of a weapon.
So if there are different inferences that could be drawn from the evidence that's in this record, why is this not a mixed question of law and fact, and beyond our review?
Yes, Your Honor, I contend that there are no competing inferences and that that it was objectively unreasonable, as I mentioned before, to conclude that it was a weapon precisely because
Well, what about the fact that his hand isn't showing? It's not just that he has the bulge. His hand's inside the sleeve, and he won't show the hand. What about that?
that could be a way that somebody wears clothing. I'm not sure that's necessarily indicative of criminality or possession of weapon. They had no reason to believe that he was involved in a crime at that point because they had no knowledge of what was going on outside of the building where they were doing the vertical, namely the reports of a recent robbery nearby.
Right, now, if they had all that, we wouldn't be here.
Exactly.
Thank you, counsel. We'll get to your second issue on
Thank you.
rebuttal. Counsel?
May it please the court, Sharon Knight for the people of Bronx County. Your Honors, this is a totality of the circumstances analysis, and when we look at all the attendant circumstances, there's numerous indicia of suspicious activity on the part of this defendant, and that's from
So
beginning.
counsel, how can an individual who's in, well, here it's a NYCHA building, when can they refuse or not want to speak to the police when approached without it escalating to 1, 2, 3, you name it?
Well, an individual has the right to refuse to interact with officers in a level 1 and level 2 situation. However, the police are permitted to follow that individual or pursue it further for clarification.
So when he got off at the 9th floor, if they hadn't seen the bulge, take this out of the equation for one moment. When he turns around, faces the wall, refuses to speak to them, what would they have been able to do? Or do they now have to walk away or just stand there until he moves?
Well, they absolutely do not have to walk away. They have the right to
They
inquire.
can just stand there? So what does that mean for the person's right not to have to speak to the police? Isn't that an intimidating environment, to just stand there? when a person is obviously invoking, as you acknowledge, their right not to speak to the police, to be left alone.
Well, I think what's important to note here is that it's not just that he's not speaking. This is not about this defendant
Okay,
being
what are the other
silent.
things that are going on?
As soon as the officer gets onto the 9th floor, he says, "Do you live in the building?" The defendant turned to the side. He has his hoodie on. He's hiding his face so he cannot be identified.
He doesn't want to talk to him.
Okay. But the police have a right to inquire further, to clarify what's
Right,
going on.
but that's what I'm saying. I understand that. And they made their inquiry. This is the question left open after Barksdale. He now has invoked his right. I don't want to respond. I don't want to talk to you. And he turns around, which is, of course, putting himself in a vulnerable position and making it very clear he doesn't want to have any conversation.
Right, but
So
what's-
at what point can an individual in that position truly be exercising their right? If your position is, well, the cops can just stand there and either say nothing, but stand there, or follow him around, or continue to ask him the same questions.
Well, I think as soon as this officer sees the bulge, that obviously escalates
I
the
understand.
situation.
I understand that
Can he
argument.
stay silent? Yes, he can stay silent, but the officers can also proceed and take safety precautions
But
if
my
necessary.
hypothetical was, you don't see the bulge. There is no bulge. I just want to know, I understand your point about the bulge there. We have case law about the bulge. I understand your position there. I'm just trying to understand the people's position with respect to the right to be left alone and not to respond to an officer.
I think in this situation, what's unique about it is that it isn't a NYCHA building. And part of that officer's responsibility, they have a dual function. So one function is as part of their contract with NYCHA and also as part of the trespass affidavit program. They're there to protect the law-abiding
No,
citizens
I
of
understand that, but let's say it's a tenant in the elevator, doesn't want to speak to the police, gets off at the 9th floor, sees him on the 7th floor, goes up to the 9th floor, gets out, turns their back, puts the hoodie over. Where do we go after that?
Right, but he hasn't communicated that he's a tenant.
But why should he? Isn't the point that he doesn't have to speak to the police, is my question.
In a
Isn't
level
that
one,
where this
in a-
rubber hits the road?
Right, he doesn't have to, but that's not, the officer did not do a pat and frisk based on him not speaking.
Why is
That
this
was not
different?
the
Why is this
basis.
different from Holmes, where the officer sees an unidentified bulge, calls the defendant over, and the defendant takes off down the street running, and the evidence is suppressed?
Well, it's a street encounter.
So the
It's
distinction here is that
different.
it's NYCHA.
Absolutely.
So what
There's
does
a
that
big
mean? The
difference
police
that
have
it's not-
greater rights to intrude upon the person?
Well, if we're going to go back to Barksdale, and I would say even the first department cases prior to Johnson, if it's a NYCHA building or a trespass affidavit building, yes, they're permitted to inquire whether or not this person lives in
They
the
did.
building
The
or if they're...
question is, when he doesn't answer, what is next? I'm not disagreeing with you that they can
Right.
ask. I'm not taking that position at all. I'm asking you now, what happens when the person chooses not to respond?
I mean, in that kind of situation,
Yeah.
it is, it could potentially be a trespass.
Well, it's been characterized, I thought in your argument, that his response to holding the elevator constituted some form of flight. Are you still saying that here?
It was an active evasion. It was very purposeful, it was very willful. He did not want the police to come into the elevator. And that's because he knew he had just robbed someone with a machete at the corner 5 minutes prior.
Yeah, but the police don't know that. Let me ask you this hypothetical. Let's say when they got up to the 9th floor and they follow him up, and that's all okay, they follow him up, and they are asking him, whatever they're asking him, and he's right there by his apartment door, and he lets himself in, and he closes the door.
That
Did the police
changes-
have any basis on what they had seen up until that point and what they had interacted with him to do anything further?
He had identified the bulge in his sleeve at that point. They identified that almost immediately
Let's say,
upon.
in other words, he didn't quite get, it turns out he lives on the 9th floor, right? We know that from later developments. But if he had actually gotten to the threshold of his door and had stepped inside of his apartment, based on the information that was available to the police at that point, could they have done anything?
No, I don't believe that they would be
So
able to.
what's different if he's now in the hallway? What makes it different from being on one side of the door?
Because in your hypothetical, he's in his own home, and there are certain protections that go along with being in your own home.
But you would actually give him less protection in his apartment building than you would on the street.
But it's not in his apartment building. He's in an open area. The officers have no idea. He has not communicated to them that this is his apartment building. So right now, he's someone who could potentially be a trespasser, be involved
The
in
default is whoever's in that building is a trespasser. You've got to prove to us otherwise.
Yes, in those,
Would that be true on the street? Kind of, if you don't want to talk to the officer and the officer has asked you, where are you going, what's your name, you don't want to talk to them, and they continue to ask you, is it the same default? I assume that this person is committing some crime or about to commit
No,
some
not at all,
crime.
because these buildings are private buildings. It's a private space. It's not a public space.
It's
Nights
because,
are public
again, there's
housing.
nothing to suggest that he's not a tenant, is my point. If you have nothing to suggest someone is not a tenant, and they do not speak to you, what is the extent of the officer's rights?
Right, but there is something to suggest that he is not a tenant. And when you look at the First Department cases, you have a right to ask someone whether or not they live in the building when they're acting in a manner that's inconsistent with that of a resident or a guest. His behavior on the 7th floor was inconsistent with that of a resident or a guest.
You mean returning into the elevator and not letting a police officer on?
Yes, very purposefully. Yes.
Why is that inconsistent? A tenant may not want to be in an elevator with a police officer.
I don't think it would have been as purposeful. He's pressing the button. He's
So you say the
clearly
record,
avoiding them.
your adversary says otherwise, but you say the record clearly establishes that the police testified that he was pressing the button to
Oh,
close
it's
the
in
door.
no, the record clearly
What hand
supports.
did he use?
says,
What hand did he use?
I do not believe it says the hand, but he says he kept pressing it. He said, "Police, hold the door." He kept pressing it. Now, it's important to note that these officers are in the building.
Didn't they testify that it might have been heard as "please hold the door," not "police"?
There was a little bit of debate, but he said police.
So it might have been that he didn't realize they were police in that moment.
I don't believe so, because
Not a nice
they had
tenant who won't
shields
let someone
around.
on, but
No, because he looked at them. He stepped out, he looked at them, and even though they were in plain clothes, they had shields around their neck.
Counsel, do you care to address the statement issue?
And specifically, how does this statement fall within the line of cases on spontaneous, utterances by a defendant when it takes place 15 or 20 minutes after they transport him to the precinct and then get him kind of the condition that he's given to speak with them? I don't see how that fits in our traditional line of cases in this area.
No, I mean, both statements were spontaneous. It was conceded.
Well, the first one they concede, but the second one they don't, and it seems like that one, it's a spontaneous statement, a conditional spontaneous statement, and I don't see how that could be a spontaneous statement.
I guess, is there any view of that evidence that the police officer could have reasonably thought that giving him the sandwich that he asked for was likely to elicit an incriminating response from him?
I don't believe so, no. I mean, it's something that's routinely done with
Which would be
people in
different
precincts, they
if
give
they
them
brought him
food.
into a room, they gave him a ham sandwich, and he just starts talking. But here he said, "Give me a ham sandwich, and I'll tell you what you want to know," essentially something like that. I know how this works, so doesn't that change the equation? And do we then go back to they just gave him a sandwich?
Well, I don't believe it was conditional upon the ham sandwich. This was someone who was willing to cooperate. He basically got in the police car
what
and
does
said,
it
"I'm
mean?
guilty."
What does it mean? Get me a ham sandwich and I'll tell you what you want to know.
He says, "I'm hungry, I want a ham sandwich, so when I get to the precinct, give me a ham sandwich, and I'll talk to you further." But pretty much
Sounds
he's telling them,
Boy,
"I'm
that sounds like a
guilty."
very different sentence from what he said.
Sounds like offer, acceptance, consideration.
Thank you, counsel.
Thank
Mr.
you.
Moralia?
Thank you, Your Honor. I'll just address the statement issue briefly.
Please.
I would suggest that this is a classic example of a situation where the suspect in custody tells the officer who's holding him.
How
if
is
you-
it coercive? Isn't that what Miranda is meant to prevent, is a coercive environment? How was this coercive?
Your Honor,
The
when-
police didn't say, "If I get you a ham sandwich, will you tell me, what I need to know?"
I'm making absolutely no argument that this was coerced in the, violation of due process or any sense like that. We're dealing simply with the rule in Miranda which says that when you have a suspect in custody, before any kind of questioning or the functional equivalent of interrogation
Well, that's what
can
I'm trying to,
happen.
how is this, I don't, how is this
Under
a
these
functional-
circumstances where the suspect says to the officer, if you get me some food, I will tell you what you want to know, meaning I will give you a statement about the case you're holding me on, there can be no other view. I can't imagine a case that would be stronger for importing to the officer that he knew or should reasonably have known that the suspect, upon receiving the sandwich, was going to tell him what he wanted to know, namely make an incriminating statement about his case.
But it seems to me that part of the equation is whether the police initiate that, and the police didn't initiate that. The
Whether-
defendant initiated that.
Whether they initiated it or not, the officer now has a suspect in custody. The rule is pretty clear. To protect people who are in custody from the coercive environment and all of that, there's a prophylactic rule in Miranda. The suspect says to the officer, if you get me food, I will give you a statement. He's on clear notice that he is liable to provoke a
suppose that
statement by
if-
giving the
If
sandwich.
they've deprived him of food, you know, for a long period of time, and he said, get me some food and I'll tell you what you want to know, to me, that seems more like what Miranda is.
That's in the
intended to
coercion,
avoid.
that would be a coercion case. I would put that in a, if suppression was sought on the grounds that the police did something that, overbore the will of the individual. Here, we're dealing with a violation of the rule, the clear rule in Miranda.
Thank you, counsel.
Thank you.